Okay, so welcome everyone to our Caregiver Collaboratives Educational Forum. And today we're going to have an update, a legal update in terms of the changes to Medicaid and also the new power of attorney form. So I'm Colette Phipps. I'm with the Westchester County Department of Senior Programs and Services and also the public-private partnership for aging services. And I'd just like to bring you greetings from the county executive, George Latimer, and also from May Carpenter, our commissioner. We're very excited about this morning. We know that we can never know too much about this topic, and we have a wonderful representative to share information with you. So without further ado, I'd just like to introduce Jerry Brooks and Ellen Woods, who are the co-chairs of our Caregiver Collaborative.
Good morning, everyone. Good morning. It's always a privilege to be here with everyone. And thank you for joining us. And I know Deep will give us a fabulous presentation filled with a wealth of information. And now I'd like to just turn it over to Ellen, who'll introduce Deep.
Okay, so good morning, everyone, and thank you, Colette. So today we're fortunate to have Deep Mukerji, who is a White Plains attorney who conducts general law practice in the areas of elder law, Medicaid planning, estate administration and planning, guardianships, real estate, and trusts. He is well known for his work in the elder law arena, and he has his own practice. But before he opened his practice, he worked in a New York City law firm. He was also counsel to the firm of Keene and Bean. He also worked earlier on in the Westchester County Department of Social Services. Deep received his JD from Fordham University School of Law and his BA from the University of New York at Buffalo. He's admitted to both the state courts of New York and Connecticut, and Deep is very active. He is active in the New York State Bar Association. He is currently the chair-elect of the Elder Law and Special Needs section. He's also the former chair of the Elder Law Committee of the Westchester County Bar Association. He's on the board of directors for the Center for Aging in Place. He also serves on the Long-Term Care Council of Westchester and participates in the Senior Law Day and the Caregiver Collaborative of Westchester County, and also the Public-Private Partnership for Aging Services. So thank you for finding time, Dee, to give us the presentation today. You seem to be very busy in the elder law arena. So thank you and welcome. I'll turn it over to you.
Thanks, Ellen. Good morning, everyone. Yes, I'm happy to be here. It is busy, but you know, we're going to talk today about what's going on with these various things, and there is so much going on. It feels like a full-time job just keeping up with some of this, with some of this stuff. It's also constantly evolving, and what I tell you today, there's going to be some question marks still, and they're not answered. So I think I have a lot to cover, so I'm going to talk fairly fast, but I want to leave some time for questions at the end. So I'm going to try to, I should be able to do this. Let's see. Oh, Colette, can you make me a co-host of the meeting so I can share my screen? Okay, good. Good. All right. Let me see here. Okay, where's good. All right. So pardon me on this because these PowerPoints don't always come across well on my iPad. I'll try, and if anybody needs these later, if they want them, I'm sure we can make arrangements for people to get them. All right, so the first thing I'm going to talk about is Medicaid. And I have to do it's got to be a little bit historical here, because this goes back over a year. It goes back to January 2020, before all this, before the pandemic started. Okay. And so usually what the governor does with his budget is he puts his plans in. He says, you know, this is what we're going to do. This is how we're going to save money. This is how we're going to spend money. So in 2020, he did something different, though. What he did was he said, you know, we need $2.5 billion savings in Medicaid, but I'm gonna punt this over to this Medicaid redesign team too. You know, there was an original one a few years back, so this was considered the MRT2, and he charged them with coming up with proposals for finding that savings. So in March, they came down with a report of about 50 changes. Now, honestly, most of those, they all were suggested by the Department of Health or by the governor's office. So, you know, it's a little bit of a game. But all right, so they said they suggested 50 changes to the Medicaid program. Not everything got approved, but some of the things did get approved, and they were included in the final budget. And that was in April. Okay, so you know, things were starting with the pandemic and whatever, but they, you know, the New York State budget was passed on April 3rd, and a lot of these things were included. Some of the things are also require regulations, and those are still in process. So I'll talk about those in a little bit too. So these are the big changes that we're concerned about in the law. All right. That were in this budget process. Okay. One of the big things that you may have heard people talk about is transfer penalties for home care. Okay, for home care Medicaid, for MLTC, the law provides for a 30-month look back. All right. Currently, there's a 60-month look back for nursing homes. All right, there's transfer penalties and a 60-month look back for nursing homes, but there was never any transfer penalties for home care, and I'll talk a little bit more about what transfer penalties actually are, but just to let you know. So that was a big change. All right. The other thing that they said was, if you wanted to get into the MLTC program, all right, if you wanted to get MLTC services, managed long-term care services, you needed to need assistance with more than 2 activities of daily living. All right. So more than 2, you know, that's a little bit debatable too. Does that mean 3? You know, the way it's written, it says 2.5, you know, it could be 2.1, it could be, you know, but what does that actually mean? Anyway, so you need assistance with more than 2 activities of daily living. If there's a diagnosis of dementia, then assistance with more than 1 would be required for MLTC. All right. So that was a second big change. Then the third thing is that the law calls for new home care assessments to be done. All right, and this is not the conflict-free evaluation. This is an assessment that would be handled actually by a single statewide agency that would do all home care assessments for the state. All right, and this assessment would be used, plus there would be a new evaluation tool. So there's going to develop a new evaluation tool, and it's going to be somewhat based upon the ADL requirements, of course. So it's going to be a modified evaluation system. So there's going to be these new home care assessments handled by a single state agency. There's no longer going to be public health nurses or MLTC agencies that are doing the assessments. The assessments are going to be done independently by an agency. All right. So, and then the fourth thing that was of concern was there was a proposal to create a medical panel, an independent medical panel that would review high utilization cases and to determine whether those guys are appropriate for home care. So, and it was kind of unclear. It was something, you know, it was left up to the commissioner to determine what these high utilization cases would be. You know, in a lot of the legislative and regulatory language, the standard was kind of mentioned a few times, and I think this is what's coming up, is that it's going to be 12 hours, more than 12 hours a day. So anybody who's getting more than 12 hours a day of care would be subject to a review by this medical panel regarding their utilization. All right, so these are the four main things. Okay, so here's the home care thing. There was only a home care look back for nursing home Medicaid. Now, with the law, it became effective October 2020. All right, that was when that law became effective, October 1st, 2020. Now, the way the law was written was that it said that it would go back to 2006, all right, which was the DRA. You know, that happened. It happened to just be amending that particular law. So, you know, which was clearly ridiculous. It wasn't going to go back to 2006. They're not going to impose 2.5 year, you know, or 30-month look backs on all those cases. What the Department of Health said, and they've clarified, and they've said it's within their authority to modify the law, I guess, is that they would only apply. This would only apply to transfers of assets that were made after October 1st, 2020. Okay, so so if you gave away $500,000 anytime in 2020 before October, that would not count. All right, so it's only transfers subject to penalty would be after October 1st, 2020. All right, so what they said was they were going to have people submit financial documentation. Say if you're doing it in 2021, it would go back to October 1st, and it would be sort of like a month by month. This is what they did when they changed the nursing home rule from 36 months to 60 months. Is like every month it was further, you know, it added a month. It always goes back to the same date, and that would be October 1st, 2020. So because of the pandemic, because of a public health emergency, this look back never materialized. All right, we're still looking at it, and we're still saying, you know, okay, it's out there. You know, and we've actually had discussions with the Department of Health regarding when it's going to be implemented, and they're very equivocal on this. You know, we don't know. So right now, because of the public health emergency, it's been pushed back to January 1st, 2022, but it could be later. All right, it could be later. So right now, it's still in limbo. This idea of the 30-month look back for home care is not implemented, and you know, is not expected anytime before January 2022 or later. Okay, it's going to be, it could be delayed even further, so we're going to just keep an eye on it. And you know, one of the things to watch though is that when they finally do put it in, it's going to affect increases in coverage. All right, which would be like somebody who's on the Magi Medicaid or straight, you know, actually it's really just Magi Medicaid. Magi Medicaid, if they needed long-term care, that would be an increase in coverage. If they weren't receiving long-term care before and they suddenly needed it, then the look back would be implemented, would be instituted. All right. However, you know, our understanding is that it does not apply to recertifications, or doesn't apply to people who are already in receipt of home care services. All right, so there's no look back for people who are already receiving services. Okay, so this is where it gets a little tricky. According to the law, this penalty period, all right, a penalty period is based upon a transfer of assets for no consideration. So, or for less than market value. So if there is a transfer of assets, and a person is seeking home care services, in order for this penalty period to work, all right, they would have to be receiving services that would otherwise be covered by Medicaid. Now, this would, as many of you know, this would be impossible under the current laws, since you can't be a private pay MLTC patient, okay? You can't be a private pay CDPAP patient, all right? Those are only Medicaid programs, so you can't be receiving services that would otherwise be covered. As this gets clarified, I think that what our understanding is that there would need to be medical documentation of the need for long-term care. If that was there, they wouldn't actually be receiving the services. They would need to have a medical determination. So that, I believe, will be clarified down the road, but I don't have a real great answer for you on that one. Then you'd have to have less than $15,900 in assets, which is the Medicaid standard. And then your other insurance, Medicare, Medicaid, all Medicare, third-party insurance, all must be exhausted. All right. So, I didn't include this transfer, but this thing about transfers. But how a transfer, if you're not familiar with how a transfer penalty works, it's sort of like this. Say you transferred $13,000. All right. You gave it to a child. And you gave that, and the assumption, the presumption is that you did it to qualify for Medicaid because you wanted to get down to that $15,900 limit in assets. Okay, so if you gave somebody $13,000 and then you submit as financial documentation with your application, and that is indicated, that's on, it's on the application, it's within the look back period, it's after October 1st. What they do is they take what's called the regional rate that they establish every year, which is a nursing home rate, actually, and it's around $13,000 right now. It's considered to be the monthly cost of a nursing home. All right, and it's set by the state. 13,000 is for us in Westchester. We know that's kind of low for a private pay rate, nursing home rate. But anyway, that would be the rate. That would be the number that's used. Is this number that's established by the state every year. And so they'd say, all right, well, you transfer 13,000. We have this regional rate. 1 month at a nursing home is 13,000. They divide the 13 by 13. And you come up with a penalty period of 1 month. All right. That means from the date that you applied, you're receiving services, you're otherwise Medicaid eligible, then they're not going to pay for 1 month. All right. That's the penalty, is the 1 month. So that would, and correspondingly, if it's 26,000, it would be 2 months of a penalty, and so on. All right. So there's certain transfers that are exempt. Now, I didn't put them all in. It would take, we would be here all day. But when we talked about exempt transfers, first thing, and I didn't put it in the slide, but the first thing you should be cognizant of is that transfers to a spouse are always exempt. All right, those are always exempt. You can always transfer your money to a spouse. And with the spousal impoverishment standards, which apply to MLTC, that spouse can have over $100,000 potentially in assets, and you will still qualify. But there are certain transfers that are exempt in the regulations and in the statute. And the interesting thing is, because the way that these regulations and these laws were written, they're always key to institutionalization. All right, the trigger was always institutionalization. So the first one, which is one that people use a lot, is you could transfer your homestead, all right, your home, to a child who's been living with you for 2 years prior to the date of your institutionalization and taking care of you. All right. If the child has been living with you and taking care of you for 2 years prior to the day you went into the nursing home, then you could transfer the home to that child. All right. So that was one. The other one that I'm just highlighting today is that the sibling with equity interest. All right. So if you have a brother and a sister and you got family property, that's the homestead. It has to be the homestead where everybody's living there. Okay, you're living there with your sister or your brother, and you've lived there for years, and maybe the house belonged to your parents. It's a very common situation. If you could transfer the homestead to that sibling, all right, to your brother or sister, if as long as they're living there for 1 year prior to institutionalization. So, we've been going back and forth with the state over this, and it's like, well, what are you going to do about this? Because it says institutionalization. It doesn't say prior to needing home care services. So, are you going to change the law? Are you going to put that in? And they don't want to do anything regarding this. They want to say, nope, that's what the law says. It's institutionalization. That means that that the homestead exemptions are out the window for home care. All right, you can't transfer property. Apparently, I mean, again, this is a developing story. I don't know where it's going, where we're going to end up, but so far the state has said, and in their state plan amendment, they responded to this, and they said, that no, institutionalization, that's the trigger for these exempt transfers. So that if you did this transfer and applied for home care, you would be socked with a transfer penalty. All right. And what does that mean? Well, the homestead is exempt when you're living there. When you're receiving home care, the home is exempt. Your home, because you'll live there, it's an exempt asset. All right. Subject to home equity limits. All right. Subject to a home equity limit. However, you're living there, it's exempt. They're not really going to bother you. All right. By the way, the limit is about $840,000. And if two people are living there, it could be up to like 1.6 million. So if you're living there, it's exempt. But then what happens is, if it's still in your name, then it will become part of your estate. It could potentially become part of your estate, and at that point, it's subject to a claim. It's subject to a claim for an estate recovery claim. So Medicaid could put a lien on the house. There's a variety of different things that they could do to get that money back. So that potential is still there. I mean, it's always been there, but it just, you in the past, you could make a transfer. You could transfer the house at some point, and that would take it out of your probate estate. Okay, let's see. The other thing that we really don't know anything about here, and is a big question, is how pooled income trusts are going to be created, are going to be treated. All right. Pooled income trusts, everybody's using them for home care. It allows people to put their income surplus into this pool trust, hold it in an account, and then use those funds to pay their household expenses, to pay their rent, to pay anything basically that's non-medical. So to go back and forth, there's been state policy directives about this, talking about it, that they're not really, when you transfer it, it's first of all, it's what's called a sole benefit trust. When you have a pooled trust account, you're the sole beneficiary. It's only for you. All right. It can't be for anybody else. And that's one of the rules that's built into the laws on a supplemental needs trust. So it's a sole benefit, but also, and this is one of the arguments we've been making, it's a transfer for consideration, meaning that you put this money into the trust, but you expect to get it back. You're going to spend that money. All right. You're getting value for putting it in the trust. You're getting it back. And So because of that, we don't believe that they should be able to put transfer penalties on. And the state has previously said this, that, yeah, I mean, it's not an exempt transfer. In the law, it's strictly, and for people over age 65, there should be a transfer penalty for any transfer into a supplemental needs trust, including a pooled income trust. All right, that would incur a transfer penalty. However, if it's coming back, then it reduces the amount of the transfer. So right now, it's not clear exactly how that will be treated. Okay, does that mean that you're going to put the money in and then you have to spend it all within 1 month? I mean, what we're hoping is that does not happen. All right, so there's a question about at what point will the Department of Social Services or the Health Department or HRA, at what point will they look at this and start and do an accounting and say, oh, well, you didn't get this money back, so this is going to be a transfer. I mean, generally, I would think that when they look at these is usually on research, so it would be annual, but that's really not clear what they're going to treat the accounting period to be. And this is important because, although like, if you rent a place, you put the money in and then you can pay your rent. So it gets spent down every month pretty much. But for people who own homes, sometimes they want to save some money in there to pay the taxes. All right. And taxes are whatever, 3 times, 2-3 times a year, you have to pay taxes. So you save up money for that and you put it in the pool, you have it in the pool trust so that when that tax bill becomes due, you can pay it. And that would certainly be problematic under what is proposed so far. But again, it's a wait and see, this is wait and see. We have no policy directives from the state. And I wouldn't expect one. I would expect one if they're going to implement something in January. I would expect something in December. All right, they're not going to put out anything before then, probably. And if it gets delayed even further, it could just go on. So anyway, that is certainly something that is unclear here in the law. So, all right, now we have new home care regulations relating to the ADLs. All right. So like I said, systems with more than 2 or more than 1. All right. Again, this has been pushed back. This is not happening right now. The regulations have been proposed. Okay. They've been proposed, they've been published out there. They published preliminary regulations a while ago. There was a comment period. The Bar Association, our elder law group, and a bunch of people commented on those regulations and expressed some of our concerns relating to them. But they're still in the process of being finalized. So we don't know what they're going to look like. But the regs, interestingly enough, there's when we talk about activities of daily living, there was no actual activities of daily living. There was no definition in what the activities of daily living actually are in the current regs. So in the new regs, there is a definition of what the activities of daily living is, and this is what's in the new regs to be implemented. The ADLs are defined as bathing, personal hygiene, dressing, walking, locomotion, transferring onto or off the toilet, toilet use, bed mobility, and eating. These are they're now defined as the activities of daily living, and those are the ones that will be used to trigger a MLTC coverage. Okay. So they're talking about, as part of this, there's going to be a new task-based assessment tool. All right, so it's going to be based upon those ADLs. It's going to be task-based. Nobody knows what it's going to look like. They're supposed to actually do, like I said, there's going to be a single statewide agency. They're going to go to the market. They're going to go to the market relating to, to try to get this contractor, a statewide contractor who's going to do all these assessments. There's, well, as far as I know, there's only one statewide contractor who would be able to handle this kind of thing because they're already in position, and that's Maximus. So, I think they're all likely suspect in terms of being the agency that will do this. That is completely off the record, of course, but that's what we think. Anyway, so the other thing is that these assessments, as you know, are generally done on a 6-month basis. But now, under this new scheme, the assessments are going to be done once a year. All right. Clearly, if there's a change in status that requires another assessment, they'll do them. But the routine standard assessments are only going to be done once a year now. All right. And here's the special medical panel. All right. And it's going to be, again, this says, just to go back to this new agency is supposed to be in place by October 2022. That may be when we start seeing the application of the ADLs and the new and this new task-based assessment. Just don't hold your breath. We don't know. I don't know if they're going to actually have somebody in place by 2022. The regs are still out there. They still have a lot of work to do. There's a lot of work to be done before that gets implemented. So, but October 2022 is possible for when this was going to come into be put in place. All right. So the utilization review. So like I said, they're going to look at these cases. They're going to see whether they can be determined appropriately at home. And the regulations say 12 hours a day. Not final yet, but that's what the regulations say, that they can look at any case that that's getting more than 12 hours a day and determine. And what are they going to do? Are going to say, there's only 2 ways to go with this, right? One is, well, you don't need more than 12 hours a day. We're going to cut your hours down to 8. Okay. That's option 1. And option 2 is, well, you're getting 24-hour care and you need 24-hour care. And so because of that, you can't be maintained at home. We're going to send you to a nursing home. I don't know what the other choices will be. All right. There's, that's completely unclear in any of this. So, this is very concerning to us, and especially, when we enjoy having good home care services available, and things that enable people to stay home and not go to nursing homes and not go to facilities. So it's very concerning. And okay, so that's it for the Medicaid piece, and I'll get back to when people want to ask questions. But I just want to talk a little bit about the power of attorney. So just because there's this new law, people don't know about it yet. What's the durable power of attorney? It's a durable power of attorney. It's a durable statutory power of attorney. It's created by law. The actual form is in the law. It's in New York General Obligations Law. There's a copy of the form right there. And generally what you want to do is you want to use that statutory form, all right, because it's there. And it has to be honored if it's a statutory form. So it allows you as principal to appoint an agent to do a bunch of different things, all right, depending on what, depending on how the power of attorney is written. It does not confer healthcare decision powers. That would be handled by a healthcare proxy, but just about anything else can be handled by a power of attorney. Person has to be competent. They have to know what they're doing when they execute the document. Once it's executed, though, it will survive incapacity. That means if someone becomes incapacitated after having executed a power of attorney, that power of attorney can still be used, and that's why it's called durable. Okay, it survives incapacity. All right, so we have to go back. I'm sorry, I'm gonna do a little history lesson on this. In 2009, the current form is when it actually started. All right, there was a huge reform movement based upon some cases that were egregious. There were egregious misuses of the power of attorney. There was a feeling that they needed, that in order to sort of help counter elder abuse and fraud, that you needed a stronger form. If anybody recalls, prior to 2009, form was very simple. It was just like a one-page thing you get at the stationery store. You just sign it and you were done. Excuse me. What happened was, though, the law changed. We got this stronger, new, strong form in 2009. But if you had an old one, it was still valid. Okay, the older forms executed prior to 2009 were still valid. Then in 2010, there were some technical changes made. Things regarding revocation and successor agents were changed. All right, so 2010 there is basically the form that we use now. If you had a 2009 form, it was fine. You could still use it. It was valid. All right. So these are just some of the formulaic requirements. There's got to be a caution at the front. There's also, this was added in 2009, that there had to be a statement by the agent saying, and this is the first time that the agent actually has to sign the form, is in 2009, because before it was just a principle. You said, oh, I want my cousin to be my agent under a power of attorney. So you could appoint your cousin, and the cousin might not even know about it. You had this form, and you just named the cousin, and that was it. Starting in 2009, the agent actually had to sign the form, and they had to accept the responsibilities of acting as your agent. And there was a statement that said you're going to act in the best interest of the principal. Okay, that you had to act in their best interest, and not on your. You can just the cousin couldn't just say, all right, I got a power of attorney. I'm going to take all this money. I'm going to move it to me. I'm going to move the house to me. I'm going to just, and if there's no real good reason for doing that, there may be a reason. If it's in the principal's best interest, you can do it. But if it's not, then you can't do it. That's what the statement says. So there we go. Everybody has to sign. They have to be notarized. All the signatures have to be notarized. This was the interesting thing, that they said that the form that you used, if you wanted it to be a statutory power of attorney, it had to be in the exact wording of the statutory form. Exact wording. No, you could not change it at all. The only place that you could change it was in a modifications section. All right. So you could not modify the form. It had to be in that form that's in the law books. All right. The statutory form had to be used, and no changes were allowed in any other parts of the form. And this led to a lot of confusion, a lot of problems. All right. People were not, it's like, well, we have to do a word by word analysis to make sure that nobody changed anything. Or, what about typos? Typos, I think, are okay. If they're acknowledged as if they're clearly typos, but otherwise, they were problematic, and it made banks really reluctant to accept powers of attorney. Okay. So one of the things is this was a 2010 prior powers of attorney were not automatically revoked. You had to have a statement that said, I'm revoking my old powers of attorney. All right. But like, well, there's also, I mean, and this is something that I would put in my powers of attorney, is that, you know, if I gave one to someone for a special purpose, that is still exists. Because remember, there's a million different kinds of powers of attorney. A proxy for voting stock is actually a power of attorney. There's also, you know, the banks have their own forms, right? Are those statutory? Well, some of them are, some of them aren't. So usually you want to sort of leave those in place. Okay, so also, let's see, I'm going to move a little bit more quickly, I think. Gifts in excess of $500 in the aggregate, okay? For gifts in excess of $500 in the aggregate, then you had to have a gift writer. So there had to be a special gift writer. And this writer required 2 witnesses, all right? This is being changed. This is changed in the new law. This is one of the significant changes. Was this idea that you had to have a gift writer that allowed gifting provisions for anything over $500 in the aggregate. Okay. So there was this form. There was this, you know, and there was confusion. You know, when do I need a statutory gift writer? And you know, the idea was that if you're doing any estate planning or anything like that, the gift writer was absolutely needed. If you're going to create a trust, any of that stuff. In fact, and we've been kind of going back on this one, but with the SNTs, with a pooled trust, a lot of times they were saying you had to have a statutory gift writer in order to create a pooled income trust. A regular power of attorney would not be any good. But I think that's sort of been turned around. Anyway, so, all right. So now we get to the 2020 changes. All right. Now, the Bar Association, you know, our elder law group, and in fact, the entire association supported reforming this because it was too confusing. The form was often rejected by banks because they didn't want to deal with this exact wording. And they did, you know, they didn't, frankly, they just didn't know what to do with some of these forms. So in December, signed into law by the governor in December 2020, is this new law reforming the statutory power of attorney. And so instead of having the exact, I forgot. I have to let people in the lobby. I'm sorry. I realize I'm the host, so I got to do that. Okay. So under the new law, the 2020 law, there has to be substantial conformance with the statutory form rather than exact wording, so that it could be changed a little bit. It could be fixed. So like even when there were typos in the old form, nobody wanted to change them because it would have created it might have invalidated the form. So, but now with substantial conformance, and substantial conformance is defined in the statute. So as long as it conforms in substance, all right, it means the same thing, then the words could be a little different. Okay. You could just put in, instead of, if you wanted to leave out some sections, you could just put intentionally omitted. You can just drop those off. So the requirement for 2 witnesses is still there. Okay, there's still 2 witnesses required for this form. That wasn't in the one that we originally proposed, but the governor asked for a chapter amendment to the law, and that imposed that. So now all powers of attorney require 2 witnesses. All right, and so that's going to, you know, going forward, that's going to be the law. One of those witnesses can be the notary. Remember, everybody's signature has to be notarized. So the notary acts as one witness. So there would be one additional witness who would be a disinterested person, somebody who's not, named in the power of attorney and not going to benefit from it. So, that requirement is still there, and in fact is even broader. Some of the other things that have been added into this new law is that a person or institution, if you're asked to accept the power of attorney, you can ask for an agent's certification. That's similar to what we do now. There's an affidavit of full force and effect that the power of attorney is still good, the person is still alive. All right, that's important. Powers of attorney are no good after somebody dies. All right, so they have to, it was not revoked, and etc. So you can certify that as to these facts. Now, if there's a question of law, the institution can, or person can ask for an attorney's opinion letter relating to that. All right, they have to state what the reason is, but and most likely would have to do with the validity of the form. People have been asking about, like, what is, what would they ask about? It's like, well, honestly, I probably think that they're going to be more likely asking about old forms and saying, are they still valid? So they're going to ask for an attorney's opinion letter, because it has to be a matter of law. It's not going to be a matter of fact, whether the person is alive, whether the POA has been revoked, anything like that. Those are factual matters. This would the opinion letter would only cover matters of law. So now, like, say it's a bank, the bank must accept or reject the form within 10 days. All right, so they got 10 days to look at it, to review it, do whatever they want, and they can ask questions and whatever. They can ask for the certification, they can ask for an opinion letter, but they have to be done in 10 days. All right, so if the response to additional information, they have 7 days. All right, so if after 10 days they say, oh no, we want an opinion letter, then after that opinion letter is received, then they would have 7 days. These deadlines, however, do not apply to the Department of Social Services or to the New York State Public Retirement System, okay, to, variety of government agencies that are exempted, because they indicated that there is no way that they could stick to these deadlines. So they do not apply. All right. This is another new thing, and this is actually really quite significant, is now there is an ability for a principal, somebody to sign the form on behalf of a principal who is physically unable to sign. So people with ALS or other physical conditions, and I've done this, several times. It wasn't strictly legal when I did it, but now it's in the law. All right. What we used to always do is say, okay, this person is unable to sign. We're going to have someone else sign for them. However, they're doing it at the direction of the principal. The principal must be able to express their opinion that they want someone to sign this form for them. And then we would just do an affidavit relating to that. That's actually in the law of wills and has been in the law of wills for many years. But it was never really in the power of attorney form, but now it is. Now it is. So that someone who is unable to physically sign the form can ask someone to do it for them. All right, as long as they're able to express that opinion. So this form is not in effect yet. It was 180 days. It was supposed to be effective 180 days after signing, which is so that's coming up though. It's going to be June 13th, 2021. All right, June 13th, 2021 is when the new form will be used. Do not use a new form before then. It's not valid until then. Okay, so that's something to look out for. People are using people should continue using the old form up to that time, and some people have asked me about that. Should I use the old form? Should I wait till June? My feeling is, if you need a power of attorney, use the current form now. It'll be fine. These prior forms will all be valid. You don't have to re-execute them. You don't have to do a new one. just because the form has changed. In fact, that goes all the way back, ones before 2009 as well. Those are valid. Those forms are all valid as long as they were validly executed at the time that they were done. Then they will still continue to be valid. All right. Now, here's a question that came up recently relating to that. Would out-of-state forms be honored if they didn't have two witnesses? And the answer is yes, they're still going to be valid. All right, as long as they were executed like a, whatever, a Missouri power of attorney that doesn't require witness. If Missouri doesn't require witnesses and you did a form in Missouri, then that form will still be valid in New York because New York will honor that law. But it has to have been validly executed at, in whatever state it was. So for instance, Florida requires witnesses and always has. So Florida, so you could use a Florida form that's going to be honored here. That's no problem. But even forms that don't have a witness. Now, the other question was, do bank forms need to be, do they need two witnesses? And the answer is yes. If they want to be covered under the statutory protections of the power of attorney, they should have two witnesses. So even the bank powers of attorney in New York should have two witnesses. All right. So I know there's a bunch of questions, and I'm happy to take a look. Could I wait? Maybe I'll stop this. Okay, good. All right. Should I address? I'll address some of these. All right.
Yeah. Would you please address some of them? I think you have one from Barbara.
From Barbara, I see that.
Right.
Agent signing right away or later, and the requirement is just is that the principal has to sign. The agent can sign later. Okay, it's not going to be effective until the agent signs for that agent. But say you had say you named 2 or 3 agents and not everybody signed. Well, the one that did sign, say if one of them did sign, then it's valid for that person to use the power of attorney. And they could have done it at a later date. It doesn't, they do not have to be contemporaneously signed. It does have to be notarized though.
I think Barbara has a second question. She says,
Yeah.
to look for on a new form to prove it is the new form?
These forms usually have a date on them. And they will, they'll say, it's pursuant to, it's usually on the bottom of the form where it'll say what the date is. But yeah, I mean, I would be careful about it because there's always going to be a transition period, where especially it's going to be in June. It's going to be in the middle of the month in June. So people, some people are going to be using the old forms. I mean, I still see people use old forms. They've been using them for years, and things that are like 10 years old, and you're still using these old forms. So you got to be very careful about that. All right, you have to be very careful in terms of what what form is being used, and generally, I mean, you shouldn't have to have an attorney to guide you through this process, but I think it's gotten so complicated that I would recommend it, and to have that, and to make sure if it's after June 13th, you have to make sure that the new form is being used. And so that would be a valid question to ask anyone. These forms are going to be available on the NYSBA website shortly. I think they're talking about like next week or so having the new form available. But again, don't use it yet. Don't use it until June 13th. All right. It's still not approved. It's not authorized at this time. So after June 13th, that's when the new form should be used. All right.
On what web?
Oh, NYSBA. It's what website is NYSBA.org. Okay, that would be where the forms would be available.
Can you spell that?
Yeah, nysba.org, O-R-G. So at NYSBA.org, people, will be able to download. You can currently download the old form, but people will be able to download the new form after, probably in about a week or so. There is, the old form was free. I believe that they are charging for the new form, but I don't know how much they're going to charge at this point. But there will be a charge for downloading the new form. All right, anything else? Any other questions?
I just had a quick one. So
Yeah.
the healthcare proxy form for New York State requires 2 witnesses, but you don't need it notarized, correct?
That's correct.
Okay, all right, to make sure. Thanks.
Yeah, that's just the 2 witnesses. And that's also the formal requirements for a will as well, 2 witnesses. Usually the witness affidavit is notarized, but the will itself is not notarized.
Do we have any other questions?
All right, I guess it was clear. I don't know. I don't find it.
Deep, it was excellent. I think that Ellen wants to close us out. Ellen?
Do we?
Perhaps. Anyway, I
Okay, here we go.
Oh,
Sorry.
Here she is. Here she is. Okay.
I did hit it, but I hit it so quickly. So thank you, Deep, for your very informative presentation. I think we have a lot to keep our eyes out for, and hopefully we'll be able to have an update as the situation progresses later on in the year. So on behalf of the Caregivers Collaborative, of which of course you're a member, but anyway, we would like to thank you for your time this morning.
Okay, I'm always happy to do it.
Great.
Want to also announce, Deep, that was really wonderful and informative. This recording is going to be put up on our Care Prep website. Jennifer will be putting that up later on, I would imagine today, so that you can access it if you would like. And then Deep, I can probably just ask you offline if we can use that material, and we'll know that it's time limited, but I think that would be something else we'd want to put up on the Care Prep website.
Yeah, I will absolutely share that.
Perfect. Thank you. Thanks everyone for joining us today.
Okay.
All right.
Thanks all.
so much.
Bye-bye now. Have
Great.
a great
Thank
rest
you.
of the day. Bye-bye.
Bye.
Oh.